everyone. In this video, we would discuss top 10 landmark environmental law judgments in India. But before we delve into understanding the judgments, it is imperative that we understand what does the term environment mean and what is the need of environmental law in the first place. So, the word environment has its roots in the French term environnement, which refers to our surroundings. It encompasses everything that encircles us: the air, water, land, animals, and all that we perceive around us. Safeguarding the environment thus becomes essential because our entire existence depends upon it. Thus, the implementation of environmental laws has been and remains crucial. Now, after understanding that environment is everything that surrounds us and hence it is very important to protect it and have laws for its conservation, we would see what has been the scenario of environmental laws in India prior from ancient times and its subsequent development. In ancient India, we see that Kautilya's Arthashastra has prescribed punishment for causing environmental harm. India as a nation has long been recognized for its forward thinking approach. Despite the word environment stemming from the French term environia, ancient Indians demonstrated a profound awareness of the imperative to safeguard their surroundings. For instance, in the Arthashastra, there are penalties for particular actions like tree felling, animal killing, or harm to forests. Notably, these consequences extended beyond just the common people. Even kings were held accountable and subject to punishment if found responsible for environmental degradation in these manners. Therefore, the foundational principles of environmental conservation can be traced back to the earliest periods of Indian history. Then, in the medieval era, we know that the history is primarily concerned with the rule of Mughals and Delhi Sultanate, but we see no major laws related to environmental changes as documented by historians. That we don't have substantive documents by the historians for that era. Hence, after the ancient India, we move on to what happened to the environmental laws development in the British era. We know that whatever the British did in India was primarily for their own profit, and environmental law was no exception. Even the environmental laws during the British rule primarily served the colonial interest rather than focusing on comprehensive environmental conservation or protection for the well-being of indigenous population or the environment itself. The British enacted several laws, but they were mainly for their own benefit. For example, we can take the example of Forest Acts and the Indian Forest Acts of 1927. These laws primarily aim to manage timber extraction and the right to access the forest resources for revenue generation, and established reserved forest for the British Empire's benefit. That they demarcated certain forests as reserved only for themselves, and only the British people could extract timber from those forests, and the indigenous tribal population was prevented from getting into those forests. So we see it is an environmental law because it is related to the forest, but this is not for the conservation of forest that the timber of the forest needs to be protected, but rather for the British benefit that they will get that timber and they will sell it for commercial profit. So this is also an example of commercial law, but this was for commercial benefit rather than for the core purpose of why we need environmental law. However, this was not the only exclusive scenario. There were certain exceptions as well, because certain acts were indeed well intended to prioritize the well-being of the environment. For example, the Shore Nuisance Act of Bombay and Colaba 1853. This act was brought into place to address concern of water pollution in coastal regions. And then they also brought in statutes like the Indian Fisheries Act of 1897, the Bombay Smoke Nuisance Act 1912, and the Bengal Smoke Nuisance Act of 1905. These were introduced particularly to address concerns related to fisheries and air pollution. Now we get into the most interesting part of our discussion, where we trace the development of these laws post independence. So we are tracing the development of environmental laws from ancient India, then we saw the scenario in medieval India, then the British era from 1800s to 1947, and then after 1947 when we got independence, we'll see what happened to this domain of law. So, after the British Raj in India, India evolved its own environmental laws for the protection of ecosystem. The right to a clean environment is considered a fundamental right under Article 21 of the Indian Constitution. Internationally, the Stockholm Convention, a significant United Nations conference held in 1972, was the first major meeting addressing environmental concerns. It declared the right to live in a healthy environment as a basic human right, leading the United Nations Environmental Program to coordinate global efforts for environmental protection and preservation. During the convention, they set out common principles, financial plans, and an action plan with 109 recommendations to identify problems and take measures. The participating states agreed on 26 principles, which were known as the Magna Carta of the human environment. The Stockholm Convention is very important because it is the Stockholm Declaration's 26 principles that gave rise to the crucial aspects of this law. These include the idea of sustainable development, which advocates for economic and industrial development without causing any harm to the nature. Additionally, the precautionary principle was established, emphasizing the prevention of pollution rather than its remedy for the benefit of environment. Other significant concepts promoting environmental preservation also emerge from these 26 principles that were set in the convention. This convention was a landmark in the field of environmental law because the environmental law internationally can be classified into two eras. One is before 1972 and the other is after 1972. After the Stockholm Convention in 1972, several participating countries came up with their own legislations which was not there in the pre-1972 period. Conserving nature was more of a conscience based act where people did conservation out of goodwill only and there was no legal obligation. But after 1972, several laws were made to make it a legal obligation to save and protect the environment and to prevent its exploitation. India is no exception, so the development of the Indian laws in this domain can also be credited to the Stockholm Convention that was held in Sweden in 1972. The Stockholm Conference was attended by the then Prime Minister of India, Indira Gandhi, who was greatly influenced by the post-conference developments. So she made a lot of amendments to the Constitution of India, and the 42nd amendment made by her is also known as the mini constitution, whereby she introduced changes in Article 48A, where she mandated the state to protect and enhance the environment, forests, and wildlife. So, the significant changes that she brought in also had some features to protect the environment. Like we discussed Article 48A, we also had Article 51A, which imposed fundamental duty on citizens, emphasizing the responsibility to safeguard the environment and exhibit compassion towards living creatures. Now, we know that fundamental duties are not enforceable in courts. However, the addition of a fundamental duty for the protection of environment and to exhibit compassion shows a shift in attitude in the governing bodies, that they became more concerned about the protection of environment. Now, we can also discuss how Article 21, the right to life, gradually came to extend to provide a pollution free environment as well, guaranteeing access to clean water and quality air for all. All these developments took place after the Stockholm Convention, and this is how we can trace the emergence of Environment Protection Act in 1986, which was introduced shortly after. Like after 1972 we see there is a very short gap, and then in 86 we get the Environment Protection Act. That period was taken for framing of the laws. And then This act is very crucial because the Environment Protection Act 1986 empowers the central government to safeguard and enhance environmental quality, regulate and minimize pollution from various sources, and forbid or limit the establishments that cause harm to environment, and they can also stop the functioning of industrial facilities based on industrial considerations. So the Environment Protection Act grants considerable powers to the central government to act in favor of environment. Hence, that is how we can trace the development of these laws in India. And now we can move on to explore the judgments to understand the various principles associated with this law, and how these laws are actually implemented in real life scenarios. Okay, so the first case that we'll discuss is a very important case named Vellore Citizens Welfare Forum versus Union of India, and the numbers written after it 1996 5 SCC 647 denote the citation. You can put this citation in the search engines to get the actual case. This is for the new law students or people outside law background. So the numbers written after the case name are basically the citations to get the actual accurate case. So we'll now discuss the case. Vellore Citizens Welfare Forum versus Union of India. This case saw the development of the precautionary principle, emphasizing preventive action against environmental degradation even in the absence of scientific certainty regarding potential harm. In this case, a NGO filed a PIL in the Supreme Court concerning severe pollution caused by industries in Vellore, Tamil Nadu. These industries, particularly tanneries, discharged untreated and hazardous effluents into rivers, causing significant environmental damage and health hazards for local residents. The case focused on violations of environmental regulations and the adverse effects of industrial discharge on public health and the ecosystem. During the proceedings, the Supreme Court highlighted the significance of the precautionary principle in environmental matters, and it stressed the need for proactive measures to prevent environmental harm even without conclusive scientific evidence of potential damage. This case underscored the importance of taking preventive action to safeguard the environment from potential hazards, shaping the application of the precautionary principle in environmental jurisprudence in India. So, we are done with the first case, that is Vellore Citizens Welfare Forum versus Union of India. And now we move on to the second case, that is MC Mehta versus Kamal Nath. Firstly, we need to know that the name MC Mehta cannot be excluded while studying the domain of environmental law in India, and his legal battles have played a pivotal role in setting precedents for environmental protection and conservation in the country. This name can be repeatedly seen in a lot of cases related to environmental protection. So we will see this case, MC Mehta versus Kamal Nath. The doctrine of public trust in environmental law was developed in this case. This case played a pivotal role in establishing the doctrine of public trust, asserting that natural resources are held in trust by the government for the benefit of the public, emphasizing the government's responsibility to protect and preserve these resources for the present and future generations. The petition was filed by environmental activist MC Mehta against illegal mining activities in the Haryana region. The case highlighted the unauthorized excavation of minerals and the resultant environmental degradation, including air and water pollution due to the mining operations. The Supreme Court intervened and emphasized the doctrine of public trust, asserting the government's obligation to protect natural resources for the public's welfare. This landmark case led to the imposition of strict regulations on mining activities, ensuring environmental conservation and the preservation of natural resources for future generations. Some of us might also be aware of the term eco-sensitive zones. That is, the court can declare certain zones as ecologically sensitive, and mining activities or other activities which are considered detrimental for the environment are strictly prohibited in those areas. So we can relate that term to this case. And then We move on to the third case. It is also a very important case, that is Indian Council for Enviro Legal Action versus Union of India 1996. This case stands out significantly for its role in shaping the evolution of the polluter pays principle within the legal domain of India. The Indian Council for Enviro Legal Action filed a case against the chemical industrial plants in Bichhdi village, Rajasthan, for causing pollution due to their unpermitted operations. These plants produced harmful chemicals, polluting the environment, contaminating water sources, and rendering the soil unfit for cultivation. Despite court orders from 1989 to 1992 to control pollution, the plants ignored the directives. The courts held a final hearing in 1996 directing the closure of these factories and the Ministry of Environment and Forests to recover eco restoration costs. Over 15 years, the polluters used legal tactics to delay enforcement of the judgment. In response, the Supreme Court imposed a fine of rupees 38 crores on Hindustan Agrochemicals Limited for land remediation and an additional rupees 10 lakh for prolonging litigation, enforcing the polluter pays principles, which holds the polluter responsible for environmental damage and compensation for affected individuals. In simple terms, we can understand that a few industrialists ignored court orders and continued their operations that caused pollution. So the court in its final judgment made the polluters pay a hefty sum of amount as fine for polluting the environment. This is the simple principle that developed in this case, Indian Council for Enviro Legal Action versus Union of India. So, as we are done with the third case, we move on to the fourth one, that is Municipal Council Ratlam versus Sri Vardichand and others 1980. In this case, the residents of the municipality lodged a complaint citing inadequate drainage systems causing street subsidence. The municipality was directed by the court to reconstruct drains within a stipulated period. Claiming insufficient funds, the municipality requested an extension. Simultaneously, the respondents highlighted pollution from a nearby alcohol plant causing malaria and outbreaks. The Supreme Court mandated the municipality to meet its obligations, providing separate public latrines for men and women, along with morning and evening water supplies within 6 months. Stressing the right to a pollution-free environment under Article 21, the court affirmed these obligations as integral to safeguarding fundamental rights. Now, we are done with the fourth case as well, and as we move on to the fifth case, we see again MC Mehta has a presence here as well. So this case is MC Mehta versus Union of India and others 1987. This is considered one of the most landmark judgment in this field of environmental law, and this is one of the first cases you will read wherever you hear or see environmental law. So in this case, the court dealt with a situation where MC Mehta filed a petition asking the court to stop leather tanneries from dumping their waste into the Ganga River. The judgment highlighted the importance of certain laws that protect our environment, specifically mentioning Article 48A and Article 51A of the Constitution of India. The court made a strong statement comparing the situation to an industry that can't pay fair wages to its workers not being allowed to operate. Similarly, a tannery that can't set up a proper waste treatment facility should not be allowed to continue operating. This means industry should take responsibility for treating their waste properly, just as they are required to pay fair wages to their workers. And the Article 48A and 51A are already discussed in the previous part of the video, where we discussed the amendments brought in by the then Prime Minister of India, Indira Gandhi. And we already know what are the contents of these articles and how are they related to environmental law. Now, we are done with all 5 cases in this slide. Then we move on to the next cases. Our sixth case is AP Pollution Control Board versus Professor M.V. Naidu, 1994. In this case, the issue involved an industry planning to build a new factory for making vegetable oils in Andhra Pradesh. So we can understand that the name AP in the title, AP Pollution Control Board, stands for Andhra Pradesh Pollution Control Board versus Professor M.V. Naidu. So this industry bought land in a place called Pedaspur in Indore village. The main question in this case was about whether constructing the factory would breach the rule concerning eco-sensitive areas violating the 10-kilometer restriction. We discussed what are eco-sensitive areas, and here we get to see the mention of eco-sensitive areas in this case but in particular. The case is significant because the Supreme Court based its decision on one of the core principles of environmental law called the precautionary principle. This principle urges authorities to anticipate and prevent a problem rather than wait for the actual problem to happen and then seek impossible solutions. We discussed this principle in elaborate manner in one of the earlier cases, but in for our help in understanding, I can repeat it in simple terms that precautionary principle means taking care and being cautious to stop environmental harm even before it happens. So this case becomes monumental in understanding of this principle. Then we move on to our seventh case, that is Rural Litigation and Entitlement Kendra and others versus the state of Uttar Pradesh and others. The issue revolved around limestone quarrying using blasting and unscientific methods. This activity led to several landslides, causing death of villagers and damaging their homes, livestock and farmland due to the lack of vegetation. The mining operators argued that the court did not have the authority to hear the case, but the court disagreed with the argument. A monitoring committee proposed scientific mining methods which the mining company ignored. The court found that the mining activities conducted secretly had caused extensive damage to the area. As a result, the court directed the company to pay rupees 3 lakhs to the monitoring committee's fund. In this landmark judgment, the Supreme Court emphasized that quarrying causing pollution significantly affects people's health and safety. Therefore, it ruled that such activity should cease. The court also established that the right to a clean and healthy environment is an integral part of the right to life and personal liberty as guaranteed under Article 21 of the Constitution of India. This decision marked a crucial step in recognizing and protecting the environmental rights of individuals as fundamental rights. Now we move on to our eighth case, that is KM Chinnappa TN Govardhanam Godavarnam versus Union of India and others 2002. This is a fairly recent case of 2002. This happened after 2000. So here the petitioner raised concern about open cast mining taking place within a national park. This mining activity caused extensive damage to the Bhadra river, which many farmers relied on for irrigation. In its judgment, the Supreme Court made a significant decision to establish the Compensatory Afforestation Funds Management and Planning Authority. This authority's role was to oversee and manage efforts to plant new trees in place of those that were cut down, monitor compensation for those affected by deforestation, and expedite actions aimed at preserving natural forests. This ruling aimed to address the environmental damage caused by mining activities and ensure the protection and restoration of affected areas. We are done with our eighth case as well. Then we move on to our second last and the ninth case, that is Animal Welfare Board of India versus A. Nagaraj and others 2014. This is also a very recent case, and I have included this case in particular to understand that it is not only the forest, air and water that constitutes the environment, but also the animals around us are under the ambit of environmental law, and they also deserve protection from cruelty. So in this case, the court examined section 3 and 11 of the Prevention of Cruelty to Animals Act 1960. The court ruled that animal fights instigated by humans are against the law. It emphasized that organizing or promoting such fights is illegal and goes against the welfare of animals. Furthermore, the court highlighted the penalties and punishments outlined in the Prevention of Cruelty to Animals Act 1960. Now we know that there are certain animal sports like Jallikattu held in certain parts of India, which are often debated as being cruelty to animals. And this case tried to decide what activities constitute such cruelty to animals, and how are they prevented, how are they illegal, on the context of section 3 and 11 of the Prevention of Cruelty to Animals Act 1960. By emphasizing on the consequences, the court aimed to ensure that the provisions of the act are enforced effectively. The decision aimed to deter and penalize individuals involved in any form of animal cruelty, especially activities like animal fights, emphasizing the importance of protecting and respecting animal rights under the law. Now, we move on to the last case of the day, that is Almitra H. Patel and others versus Union of India and others. In this case is centers primarily on India's solid waste management. Mrs. Almitra Patel and another petitioner filed a public interest litigation under Article 32 of the Constitution of India. They aim to urgently address and enhance the existing practices concerning the treatment of garbage in the country. In its judgment, the tribunal directed all states and union territories to strictly adhere to and implement the solid waste management rules 2016. One significant outcome of this case was the imposition of a complete prohibition on the open burning of waste on lands. This decision aimed to enforce more responsible waste management practices, emphasizing the importance of following established regulations to ensure a cleaner and healthier environment in India. Now we move on to the conclusion of the entire discussion today. So, after discussing so many cases, one thing that is clear, that at the core of the environmental laws in India lies the principle of sustainable development. That in the verge of making economics and industrial progress, you cannot harm the environment. You have to conserve it for the future generations. So development should only be encouraged to the extent that it is not compromising with the needs of the future generations and not harming the surrounding ecosystems. To support this fundamental idea, the government introduced various regulations, rules, and acts like the Environmental Protection Act, Solid Waste Management Act, Animal Prevention of Cruelty to Animals Act, along with other legislations empowering courts to deliver environmental justice. However, to alleviate the burden on the already overwhelmed courts, the NGT Act established the National Green Tribunal in 2010. This specialized tribunal was set up specifically for the swift resolution of environmental cases in India. There is also a dedicated ministry to this domain in the government. The Ministry of Environment in India was initially established in 1985 as the Ministry of Environment and Forests, which was later renamed as the Ministry of Environment, Forest and Climate Change in 2014 to encompass the broader environmental concerns including climate change. Tasked with formulating policies, implementing environmental conservation strategies, and overseeing laws like the Environment Protection Act and the Forest Conservation Act, the ministry plays a crucial role in addressing environmental challenges, collaborating with various stakeholders, and representing India in global environmental forums, emphasizing the country's commitment to sustainability and environmental preservation. In today's scenario, the National Green Tribunal collaborates closely with the courts to efficiently administer justice concerning environmental matters in India. This collaboration aims at fostering the country's overall environmental well-being by addressing and resolving the issues promptly and effectively. Together, these institutions work hand in hand to ensure a balanced approach between development and environmental preservation, safeguarding the natural resources and ecosystems vital for a sustainable future, while the government ministry looks after the legislations that make it legally binding for people to protect the environment and not cause any harm to it. So we can see that there are three things: the courts, the NGT, and the government ministry that works together in the present day to ensure a sustainable future. So thank you if you are here till if you have listened till here. Thank you for being a patient listener, and we conclude our discussion here. Thank you.